Shocking defeat in court. Alberta independence rocked, but fighters make a defiant stand. A major development has rocked the Alberta Prosperity Project as the court decided to proceed with a full review of their proposed referendum question on Alberta independence. This decision has sparked a wave of discussion across the province, with many supporters feeling both concern and determination in the face of legal challenges. The app, which has been leading efforts to put an independence question on the ballot, now faces a complex judicial process, but its leaders remain committed to moving forward despite the setbacks. The journey began when app leaders, including Jeffrey Rath, Mitch Sylvester, and Dennis Maudry, formally submitted a question to Elections Alberta asking whether the province should pursue independence. The submission triggered a review under the Citizens Initiative Act, which allows the chief electoral officer to refer questions to the court if there is concern they might violate constitutional provisions. While this referral is not mandatory, app leadership believes the move was largely intended to delay the independence process, as authorities appear wary of a question that could potentially lead to Alberta leaving Canada. Legal experts have described the case as unusual, given the challenge rests on whether a question proposing constitutional amendment could infringe anyone's rights. Even the court has acknowledged that this argument is a stretch. App leaders, including Jeffrey Rath, have emphasized that the project is committed to strengthening constitutionally protected rights for all residents, including Indigenous peoples. The hypothetical concern that independence would automatically violate rights is speculative, yet it has become a central point in the court's examination. The app filed a motion to strike the referral, arguing that no reasonable legal argument exists that their question could infringe constitutional rights. The court, however, clarified that such motions are only struck if it is absolutely clear they cannot succeed. Because the court could conceive of potential counterarguments, it refused to dismiss the referral outright, scheduling a hearing for November 19th to 21st. This does not constitute a ruling that the question is unconstitutional. It simply allows opponents to present their arguments in court. App legal counsel expressed confidence that these challenges have minimal chance of success. At the same time, Thomas Lukaszuk has entered the public discussion with a counter-petition dubbed Forever Canadian, aiming to keep Alberta within Canada. This petition is focused on a question framed as whether Alberta should remain a province of Canada. Even if Lukaszuk's effort gathers the necessary signatures, legal experts note it is unlikely to block the app's referendum question, which is carefully structured under the Clarity Act and designed to be legally binding. The contrast between the two initiatives has highlighted the strategic and legal preparation that the app has undertaken compared to other, less structured petitions. Critics of the app's independence efforts argue that a successful referendum could threaten treaty rights and constitutional protections, particularly for Indigenous communities. Representatives of First Nations have indicated intentions to intervene in the proceedings, stressing that the question could have broader implications for treaties and constitutional obligations. App leaders maintain that their process is designed to respect rights while pursuing provincial sovereignty, emphasizing that independence could enhance protections rather than diminish them. Despite the court setback, app leadership has emphasized that the project remains on track. Volunteers and supporters have been organizing across Alberta, from urban centers to rural communities, educating citizens on the referendum process, the legal frameworks, and the broader political implications of independence. The project strategy includes maintaining updated contact lists so supporters can quickly sign the referendum once approved, ensuring a smooth path to gathering the legally required number of signatures. Concerns about misinformation and data misuse have also arisen, particularly surrounding Lukaszuk's petition. App leaders caution that opponents could use signature collection for political fundraising or other purposes, potentially misleading citizens about the legitimacy and impact of their efforts. By contrast, the app asserts that their process is transparent, legally compliant, and focused entirely on achieving a valid referendum. The November court proceedings are anticipated to clarify the legal standing of the app's question and address objections raised by opposing parties. While the hearing may temporarily delay progress, app leadership is confident that the timeline for a 2026 referendum remains achievable. This period will also serve to increase public engagement and awareness, as media coverage and community outreach amplify the discussion around Alberta's potential sovereignty. The ongoing debate has sparked intense public interest, with both supporters and opponents mobilizing resources, holding town halls, and engaging in political advocacy. This heightened activity reflects the high stakes of the issue, as Alberta's future governance and relationship with the federal government hang in the balance. Supporters of independence argue that greater autonomy will allow Alberta to control its economic policies, natural resources, and political priorities without federal interference. Meanwhile, political dynamics at the federal level, including Mark Carney's position as Prime Minister following the April 28, 2025 snap election, have added layers of complexity to the independence debate. Federal leadership changes, coupled with national policy decisions, continue to influence public perception and shape the context in which Alberta's independence efforts are unfolding. The interplay between provincial initiative and federal response remains a critical factor in the evolving narrative. For Albertans following the situation, the message is clear. The legal system has not halted the Alberta Prosperity Project, and despite setbacks in court, the fight for independence continues. Volunteers, legal experts, and community leaders remain committed to ensuring the referendum question is presented fairly, accurately, and with broad public awareness. APP leaders encourage citizens to stay informed, engage in discussions, and participate in upcoming events to better understand the referendum process. The story of Alberta independence is far from over. While court rulings have momentarily challenged the APP, the resilience of its organizers and the depth of public engagement underscore that this is a defining moment for the province. The November hearing, public forums, and ongoing advocacy efforts demonstrate that those fighting for Alberta's sovereignty are prepared to face obstacles, make their case, and continue pushing forward, ensuring that the discussion around independence remains alive, relevant, and highly consequential for the future of the province.